The first time I walked into a courthouse, I was scared to death. And I was walking in as a law student or an illegal intern who worked at the DA's office. So I can't imagine how much more scary it would be to walk into a courthouse as someone who's been accused of a crime. So I've put together a free guide that kind of tells you a little bit about what to expect when you're in that situation. I have found that it's usually a little bit stressful if you at least know what to expect. So I'm hoping to kind of help alleviate some fears and reduce the stress level if you at least have an idea what to expect and how to kind of be prepared for it to make the process as smooth as possible. Again, it was scary for me. Actually, the first time I went into a courthouse was when I was a kid for my parents' divorce, but that's another matter. The first time I walked into a courthouse for criminal law was as an intern. And as I said, that was scary for me as someone who wasn't in trouble, as someone who was a law student and had some knowledge and some experience, but still really scary. Hi, my name is Marcy Fazio. I'm an attorney, and even though I'm telling you a story about the first time I walked into the courthouse, that was in 2005, so 15 years ago. Now I've been practicing criminal law for 15 years. I started as a prosecutor. Now I practice criminal defense. So I help people who've been charged with a crime in the Oklahoma City area. So Edmond, Yukon, Mustang, El Reno, Norman, Moore, that area. I have found with my clients that a lot of times the questions you have at the beginning of a case are a lot different than the questions you have later on as the case progresses. Plus, later on in the case, you probably already have an attorney. So if you're watching this, you're probably at the beginning stages. You don't have an attorney that you can ask questions to. So I've put together a series of videos, hopefully helping people like you and answering some of those questions. So in this video, which is video, I think, 6 in the series, I'm going to help you by walking you through some things that you can expect from the Oklahoma criminal justice system and the courthouse. So I've got actually a written guide that I've put together, so you can just grab that guide and then you can read through it or have a copy saved or send it to somebody if you want to email it to someone that you think would find it useful. So I'm going to show you how to grab that guide, but then I'll also walk you through some of the highlights right now in this video. So to get the guide, go to my website, faziolaw.com, and I'll put the link down below. And you see over here on the top right, the resources tab. So hover over that and some other options are going to pull up, and we are going to look at what to expect at the courthouse. Once you click on that, you're going to come to this page that talks to you about the free report, which I have titled, "Oh Shit, Your Guide to Surviving the Oklahoma Criminal Justice System." Subtitle, "What to Expect at the Courthouse from Arrest all the way to the Disposition or resolution or end of your criminal case." So when you get to this page, just put in your first name, put in your email address so we know where to kind of send the report, and hit the button there to send it, so you'll get a copy in your email, but then also it'll take you to this next page where you can go ahead and check out the guide. So let's walk through it now, and I'll kind of point out some of the highlights. Again, grab your own copy and you can kind of read through it more thoroughly or send it to someone that you think might find it useful. So let's scroll through here and kind of walking through what to expect. So important footnote here is that the criminal court proceedings are going to vary greatly depending on what courthouse you're in. So for example, the Oklahoma County Courthouse, which handles Oklahoma City cases, is going to handle arraignment a lot differently than a case in Canadian County or Cleveland County. And at the same time, Oklahoma City Municipal Court, even though those two courthouses are only like 2 blocks away, they're going to handle things differently. So this is just very general because I don't know you. I don't know what county or courthouse your case is in, but the general process and procedure is the same. So it's going to be very general. You can get more specific information by calling our office. And so let's go through that. So first we've got arraignment. I have a separate video in this series talking about arraignment, so you can check out that video or you can get kind of the basic information here. An arraignment is where you're going to be informed what the charges are against you. Probably you'll get some paperwork that shows, kind of a written document that shows these are the charges. Another important part is right here. The court process is going to vary somewhat depending on if you're charged with a felony or a misdemeanor. The main difference is in a felony, you're entitled to a preliminary hearing. In a misdemeanor, you're not. And I think the guide talks about that in more detail when we get to that. But first off, arraignment. So this, again, grab this document and you can kind of go through it in more detail telling you about arraignment. After an arraignment, you're going to have basically a conference date. Different courthouses are going to call it different things. Some courthouses call it disposition. Oklahoma County on a felony, they're going to call it a preliminary hearing conference. I think Logan county calls it a preliminary announcement docket. So a lot of different terminology, but basically it's a conference date. And what that means is it's an opportunity for your attorney to talk to the prosecutor and kind of start the process. So that's going on. Another main thing that happens usually at the first conference date is your attorney would request the discovery. And discovery is a legal term that basically means the police reports, the evidence that they've got against you. So, and then usually at the first conference date, maybe even the second conference date, your attorney will just reschedule it because they have just now got the discovery. They, of course, want to review it and see the strengths and weaknesses of the case against you. After a conference date or 2 or 3 or however many you have, if you're charged with a felony, you're entitled to a preliminary hearing. Again, misdemeanors are not entitled to a preliminary hearing. But if you have a felony, you have the option of having a preliminary hearing. A preliminary hearing is sort of like a mini trial, meaning the prosecution has to put on evidence. That could be witnesses, usually witnesses, put on evidence to show the judge that there is some evidence. And so they are going to show probable cause. You can kind of see this. Let's just follow along in the guide. A preliminary hearing is where the district attorney is required to put forth evidence to show probable cause that 2 things. A crime was committed, number 1, and they also have to show probable cause that, number 2, the named defendant is the person that committed the crime. So it's a pretty low burden, and most of the time the state is going to win a preliminary hearing unless there's some evidentiary issues or some legal issues, but the burden is intentionally low because the main decision on a guilt or innocence dispute should be decided by a jury. So this is just sort of a gatekeeper function. You also would have the option to waive your preliminary hearing if you and your attorney determine that actually exercising your right to a preliminary hearing and putting that on is not in your best interest or not necessary for whatever reason. You can waive your preliminary hearing. And there are some reasons to do that, and sometimes you don't want to do that. So that's going to depend on your case. I'm certainly not giving you any advice or legal advice on whether or not you should have your preliminary hearing or waive it, but just laying forth the options and procedure. So that's preliminary hearing. After that, you might have formal arraignment. Some counties do this immediately, like Oklahoma County. Other counties will set a separate formal arraignment date where basically they're just kind of firming up the charges that you initially got at arraignment, the written document, firming that up after preliminary hearing. After a preliminary hearing, you're going to be set for pre-trial conference. Again, different counties might call it different things, but it's basically another conference date. So that's where your attorney and the prosecutor can discuss if there were any additional information at preliminary hearing, maybe additional charges were added that made your case or your situation worse, or maybe the cases got reduced and now your situation's better. So basically, if anything has changed or if there are just further issues that need to be explored, you'll have more time at pretrial conference. So that's kind of the general procedure on how your case is going to progress from arraignment. Now, how is your case actually going to resolve? There are several different ways it can resolve. There could be an agreed plea where you reach an agreement with the prosecutor about the plea and the sentence. A blind plea, which is where the judge determines your sentence. There may be some motions that are dispositive. So, for instance, in some cases, your attorney might file a motion to dismiss based on lack of speedy trial because your case was pending for 5 years and the prosecutor never moved forward on it. So sometimes a motion will be dispositive and result in a dismissal, or you could go to jury trial. So there's a lot kind of packed in here. You can go through that, but basically that's kind of just the general overview of different ways that 99.99% of cases are resolved. Either an agreed plea, a blind plea, occasionally there's a motion that's dispositive, and a possible jury trial or a bench trial. So you can go more in depth if you want to kind of read through this, or if you have any specific questions, you can call our office. Again, at this point, I'm kind of addressing this video to people who are early on in the process, so you probably aren't even thinking about the ultimate resolution yet. You're kind of in the early stages, but that gives you a little bit of an idea of what to expect from the Oklahoma criminal justice system. Hopefully that's helpful to you. If you have any additional questions or anything like that, you can leave a comment below. Go to our website and send us an email. Call us, get in touch, and we'll see what we can do to help. Good luck.